Lindsey Clancy, of course, is accused of murdering her 3 young children. She's charged with murder, but her defense team says that she was in postpartum psychosis.
She didn't deny it. Not once. Not to the police, not to the doctors, not to the jury. Lindsey Clancy strangled her 3 children with an exercise band, one by one, in their Massachusetts home. That much has never been in dispute. What the jury is being asked to decide is not what she did, but whether she was in control of her own mind when she did it. And that's where this case transforms from a tragedy into something else entirely. Before we go deeper into what the evidence actually shows, make sure you're subscribed to Crime Nest Media. Because we don't just cover the story, we follow the facts. The visual anchor for this entire trial is not a piece of evidence or a photograph. It's a question mark, hanging over 12 jurors who must decide if a woman who methodically ended her children's lives was legally insane. A woman who hours before sent her husband to pick up dinner so she could be alone with the kids.
And he is pretty much the top expert when it comes to women killing their kids. And he testified to the jury and told the jury that he believes, and he's evaluated Lindsey Clancy, he's met with Lindsey Clancy, and he told the jury that he believes that Lindsey Clancy was in postpartum psychosis and essentially was not in her right mind and thought that she was helping her kids, that she was going to take her own life, and then that she thought that she was helping her kids by taking their lives. Listen to the way he described it.
In Ms. Clancy's case, she believed that, as the jury has already heard, she was obsessional about caring for her children. She consulted with others at work to try and do exactly what was right for her children, and she believed that if Ms. Clancy took her own life, her children would be in terrible shape, and in her mind, she believed that she would be doing her children a favor by having them go to heaven with her rather than remain on earth without her doing the mothering. Her mind was very distorted like that. Ms. Clancy believed that a distorted belief that her children would just be miserable, and she could not imagine them continuing to exist and have a decent life without her being there as a mother. And so in that sense, she did what she believed was morally right, even though she understood that ordinarily killing a child is against the law. She believed that she was doing what was right for her children with her distorted, psychotic thinking about the children's need for her.
So that was
The woman who called him afterward calmly asked where he was, and then said nothing about what had just happened. That silence, that pause, that's the gap where the prosecution's case lies. And according to legal analyst Mark Better, that gap is about to swallow them whole. Bader has been watching the Lindsey Clancy trial from the beginning, and what he sees is a prosecution team that has fundamentally misunderstood its own role. They are not supposed to be the villains of this story. But in his view, they have managed exactly that. The phrase that keeps coming back is this: they've given away their credibility.
The worst kind of case imaginable. She's clearly a sick woman, but she did a terrible act that the law does not protect. And just make that argument that the law is the law. You promise to follow it, and actions have consequences as long as they're illegal. And not that would be an easy sell for the jury either, but it would be a much better approach, a much more credible approach to perhaps get a conviction. And I think, as a prosecutor, your number one stock in trade is your credibility. And I think that these two prosecutors in this case have really given away a lot of their credibility in just the way they've conducted the trial.
That's not just a criticism. It's a verdict on how they've handled everything from expert witnesses to the treatment of Patrick Clancy's family. They've given away their credibility, and in doing so, they may have given away the case. The legal mechanics here are crucial and easy to miss if you're not paying attention. In most states, if a defendant raises an insanity defense, the burden shifts. The defense has to prove by a preponderance of the evidence that the defendant couldn't tell right from wrong. But Massachusetts is different. In Massachusetts, it's not an affirmative defense. The prosecution has to disprove the defense beyond a reasonable doubt. That means they can't just argue that Clancy wasn't insane. They have to wipe out the defense entirely. They have to show that it's not even reasonable to believe she was in psychosis. That's a high bar. And according to Bader, the prosecution has spent more time tripping over it than clearing it.
Actually favors the defense for a number of reasons. The first of which is that in Massachusetts, it's just one of those strange places legally where the defense, the mental health defense, it's not an affirmative defense. There's no burden by the defense to carry. The prosecution has to disprove the defense argument beyond a reasonable doubt that she could not appreciate right from wrong, could not conform her actions to what a law-abiding citizen is supposed to do. And, the defense has experts that will certainly support that. And if the prosecution doesn't thoroughly discredit them, I mean, wipe them out entirely, by definition, that would seem to create reasonable doubt. The other problem I think the prosecution has is the prosecution itself. They're pretty unimpressive as prosecutors. They seem to lack, I think, a modern view of how mental illness works. To me, it strikes me out as something from like the 1890s or early 1900s in terms of how they're trying to convey what mental illness is or isn't to a jury. About, she's not acting crazy, so she can't be, not guilty by reason of mental disease or defect. That's just
star rebuttal witness, Dr. Ava Mack.
Then prosecution has rebuttal. They called their psychiatrist, Dr. Avra Mack, who they hired to evaluate Lindsey Clancy, who in some ways said the opposite of Dr. Resnick, that he does not believe she was necessarily in a psychosis, and that she did have some control over her actions. Listen to what he said.
I think that in the household, she was engaging in this activity methodically, which highlights to me that there was an ability to conform her behavior to expectations of living in a household.
What do you mean methodically?
As I understand the deaths, they were done methodically, and I think you asked me about that earlier, one by one, in a way that was organized and that was intended to achieve a particular goal. Similarly, her attempt at suicide was organized and thoughtful in a sense that it included as many possible methods as possible.
And as far as the killings of the children methodically, did she report to you in any way that she was given direction by this voice on how to complete the act and what exactly to do?
No, she did not.
And what about the call with Patrick? Is there anything about that indicates that she maintained some control or the ability to control herself, where she did engage in a short conversation with him?
Well, that aligns with what we were talking about before in terms of being aware that he would disapprove or disallow this, and yet she didn't say anything. She didn't say help, or she didn't say, I'm having these thoughts, so it wasn't stated.
Described Clancy's actions as methodical and organized. He pointed out that she didn't mention hearing voices. He suggested that her careful planning indicated awareness and control. But Bader says that approach reveals a fundamental misunderstanding of how psychosis actually works. People in psychosis can appear normal. They can hold conversations. They can plan. Mental illness doesn't always look like what people expect it to look like, and the prosecution's failure to acknowledge that has cost them. They've given away their credibility by trying to minimize what was clearly a severe mental health crisis. The defense expert, Dr. Philip Resnick, testified that Clancy genuinely believed she was helping her children by taking them to heaven with her. That her distorted thinking convinced her that they couldn't survive without her. He described a woman so obsessed with caring for her kids that she thought death was the ultimate form of protection. It's a devastating picture, and the prosecution's response was to argue that because she didn't seem crazy enough, she must have been in control. That's not how mental illness works. But the most striking criticism from Bader is personal. He watched the prosecution question Patrick Clancy, Lindsey's husband, and described their approach as robotic and lacking sympathy. He watched them interrogate Patrick's mother about Catholicism and mortal sin, equating murder with religious immorality in a way that seemed to mock her beliefs. He called it disgraceful, tone-deaf, unbelievable. Every first-year lawyer knows you can't do that, but they did. And in doing so, they did something even worse. They made Kevin Reddington, the defense attorney, look like the most reasonable person in the room. That's the ticking clock moment. What happens when the person who should be the moral compass of the courtroom, the prosecutor who represents the people, becomes the one the jury distrusts? Batter's answer is clear. They've given away their credibility. And that lack of credibility matters because the jury is human. They are sitting in a room with a woman who killed her children. They are angry. They are sad. They are probably horrified. And they are looking for someone to guide them through the fog of that horror. Reddington has stepped into that role. He's charismatic. He's affable. He seems sincere. The prosecution comes across as wooden, old-fashioned, out of touch. They argue that because Clancy didn't act crazy enough, she must have been faking it. That argument might have worked in 1890. But in 2026, with a jury that understands mental illness is not always visible, that argument collapses. The phrase that echoes through Batter's analysis is damning and repeated for emphasis. They've given away their credibility. They gave it away when they treated mental illness like a costume you can put on and take off. They gave it away when they made Patrick Clancy feel like a witness to be processed rather than a grieving father. They gave it away when they tried to use religion as a weapon instead of treating it with the respect it deserves. They've given away their credibility. Now the case goes to the jury. The prosecution needs them to believe that Lindsey Clancy was in control enough to know right from wrong. The defense needs them to see reasonable doubt. And in Massachusetts, reasonable doubt is all the defense needs.
If this was about 40 or so other states, the defense would have to carry a burden by a preponderance and say, no, like we've actually established that she could not form criminal intent. So the burden of proof here and the lack of it shifting, which it does not in this case, it's not an affirmative defense, is a huge, huge advantage for Clancy here. I mean, it can't be said enough how much of a big deal that matters. And I expect in a summation, Reddington would drive that home repeatedly.
Can you explain that again? Like, because I think sometimes it goes over my head, but Massachusetts is really different than most states in terms of who has to prove.
In a lot of ways.
Yeah. Just explain that again, that part.
So, the prosecution has a burden of proof beyond a reasonable doubt in any criminal case. There are certain defenses in the law that are known as affirmative defenses, in which if a defendant puts forth the defense, puts enough evidence forward that the judge is willing to instruct the jury on the defense, that the defense will have the burden of establishing by a preponderance of the evidence. It would never be beyond a reasonable doubt, but they would have to convince the jury that it's more likely than not that that's the case, as opposed to in a regular trial where the prosecution has to prove every element, everything beyond a reasonable defense. So you take the defense in this case of Clancy not knowing right from wrong. She can't conform her conduct to what the law requires. In most states, the defense would have to convince the jury by a preponderance of the evidence that defense is accurate, it works. That's a burden of perhaps greater than 50%, right? A preponderance is 50% plus one. But in this case, in Massachusetts, because it's not an affirmative defense.
If even one juror says, I don't know if she was in psychosis, but it's possible, then under the law, they must acquit by reason of mental disease or defect. It's not about proving what happened. It's about disproving the only explanation that makes sense. Bader predicts a verdict of not guilty by reason of mental disease or defect is the most likely outcome. But he also raises a troubling possibility. A hung jury, 12 people who cannot agree, a mistrial, and then they do it all again. That would be catastrophic for everyone involved, and it raises a question that deserves an answer. How do you find 12 people who can set aside the horror of what happened and just follow the law?
Do you have a prediction? I mean, a lot of people think hung jury. A lot of people think this is going to be a long deliberation. I've heard some people say they think it's going to be short. Like, what does your gut kind of tell you?
I would be concerned about a hung jury, which is the doomsday scenario for everyone involved, because that would be a mistrial, which would be nobody's fault and would mean here we go again. And the idea that this case could be tried twice, I mean, who wants that? Who has the energy, emotional stamina, bandwidth to even do that? But I think we don't know who these jurors are, but it goes back to a point you raised earlier, which is, I mean, how are you going to get 12 people in a very quick amount of time to agree about whether she deserves to be in prison? And they know she's going to prison for the rest of her life if she's convicted, whether they're told or not, or a hospital, when we all agree that she strangled 3 children one at a time with an exercise band. I mean, it's just horrifying. So I don't know the outcome. I think a hung jury, nobody wants to hear this, is very much in play, just because the idea of getting 12 to agree on this will be difficult. So I think the deliberation will actually take some time in a case like this.
And they can push them. What's that rule again? The judge can push them to keep deliberating, right?
Yeah, it's called an Allen charge in most places. I think it's called a Rodriguez charge in Massachusetts. It's a dangerous charge because that can lead to error too. So you really have to get to a point where the jury tells you we're deadlocked and we can't really do anything else. And once the jury starts signaling that we're close to roadblocked and we don't think we can get anywhere, then a judge can give them that charge. It can be controversial because you don't want a judge trying to push people to make a decision one way or the other, which could just make some people say, I want to go home. I want this to be over with. You hope these jurors are not watching any of the media. They're not supposed to, but about all the craziness that's going on outside, or you hope they're not thinking, I have to reach a verdict, otherwise someone else is going to have to try this case. Whatever the verdict is, you want each juror to be honest to their thought process and their view of the evidence and law to do the right thing, whatever that is. I just think it's going to be very hard to find 12 people to agree on this. But if you push me to say what is more likely, I think 12 people based on this evidence and based on the advocacy of the lawyers in the courtroom would probably agree on a not guilty by reason of mental disease or defect. I think is the most likely verdict, but I think a hung jury is a real possibility.
The court documents from this case are publicly available through the Massachusetts judicial record system. Search for the Lindsey Clancy case files, read the expert testimony, compare the psychiatric evaluations. And then ask yourself one question in the comments. If you were on that jury, could you separate the act from the mind that committed it? Could you convict a woman who believed she was saving her children? Or would you see reasonable doubt in every corner of this case? If this story taught you something, then like, share, and subscribe to Crime Nest Media. Hit the notification bell so you don't miss the next deep dive, because the evidence is always there. The question is whether you are willing to follow it.